Good morning, everyone. Happy New Year and welcome to our first episode of 2024. I'm back with myself, your host, Nick and Bruno. So welcome to PLA once again. We've got two questions today, one dealing with a deposit and one dealing with just different ways of buying property in currently. So Nick, we'll do the first question with you. This one comes from Agent Q, and it's about regarding a deposit. And the main question is, are they permitted to release this specific deposit? And the background is that the landlord is blatantly ignoring all their requests pertaining to the repayment of this deposit. The tenant has moved out 8 months ago already, and that they did advise the tenant to obtain some legal guidance or approach the rental housing tribunal. The tenant has not done that. But in any case, their question then is, what are the implications if they were to just release the deposit at this stage? Nick?
Okay, so what's interesting is this is coming from an agent's perspective. So there's a double sort of thing that we have to deal with here. Let's first deal with the holding of deposits by landlords and what their obligations are in terms of the law. So in terms of the Rental Housing Act, a landlord is entitled to take a deposit. It has to be agreed to between the parties, okay? And there are certain provisions within the Rental Housing Act with regards to releasing the deposits. Okay, so the deposit is security. It's meant to be kept there by the landlord. It has to be kept in an interest-bearing account until the end of the lease agreement. And the idea is obviously that it is there as security to cover any costs or outstanding amounts that cannot be paid by the tenant in the circumstances. Now, what the Rental Housing Act requires is that there is an exit inspection at the end of the lease agreement, okay? And there are two ways that the deposit is dealt with. If there is nothing outstanding on the account and there is no damage to the property, in other words, the tenant is handing back the property in the same condition that it was received in, fair wear and tear accepted, okay? The Act then provides that the deposit must be refunded back to the tenant within a period of 7 days. Okay, so there's nothing left to do on the house. You don't have to fix anything. This is a fairly easy thing to do. You just refund the deposit, including the interest that it has now accrued. Okay, slightly different in circumstances where there is perhaps something which is outstanding, or there is some work to be done on the particular premises. Okay, because then the Act does provide for the landlord to go ahead and restore the property in the circumstances. Now, what the Act says in those circumstances, okay, is that the deposit must be refunded within a period of 14 days from restoration of the premises, okay? The reason it's open-ended like that is obviously the amount of work that could go on any particular premises is anything. You know, it could be one cracked tile, it could be replacing a whole bathroom. You don't know. So within 14 days of restoration of the premises, that deposit has to be refunded back to the tenant. What we don't have in this particular question is which circumstance we sit in. But regardless of that fact, this is a period of 8 months, okay, that's now accrued in the circumstances. So if there was no damage, we've already passed 7 days. If there was damage, one assumes that it's now, the property's been restored within the 8-month period and our 14-day period is passed in any event. So from a legal perspective, the landlord does have the obligation to pay the deposit back to the tenant, okay? But that's the question in this particular circumstance is asked by the agent. The agent is an agent for the landlord in the circumstances. Okay, so from a strict legal perspective, if the agent pays back the tenant, that's actually in compliance with law, and the tenant wouldn't have a claim against the landlord. As it stands now, the agent mentions that they've suggested to the tenant to go to the rental housing tribunal or take other legal steps, which they absolutely could do to get the return of the deposit. But for whatever reason, the tenant doesn't seem to be doing this. So from a legal perspective, the tenant is entitled to their deposit. What the agent, I think, is worried about in this particular circumstance is what is going to happen with the landlord, because they have a particular relationship with the landlord. Now, unfortunately, in this particular question, you're going to have to come down to the agency agreement that's entered into with the landlord and the agency. It seems to me, if it's been a period of 8 months and there's been no communication from the landlord to the agent, either instructing them to do something or not to do something, it seems that particular relationship has broken down ultimately. And really, the agent wants to be careful in the circumstances of assisting the landlord in contravening the act in the circumstances. If I was the agent, I'd be very careful. You don't want it now. You're sitting in a position where you're holding this deposit on behalf of the landlord. The landlord's not complying with the legislation. And you don't want to be wrapped into this particular circumstance, either, if they go to the tribunal, if they go to, any other sort of legal forum. So really my suggestion would be pay back to the tenant. Legally speaking, that's a correct view. And then they need to assess the relationship with the landlord at this point, because I really think that relationship in any event is probably broken down if you haven't heard from the landlord in a period of 8 months. I don't know whether, they haven't mentioned whether they're continuing to pay for the agency fees or whatever the case is. But my suspicion is if they're not even talking to you, that's probably not happening either.
So Nick, out of interest though, so maybe just to look into that further, maybe answer this. So when an estate agent acts, most of the time they would take the mandate from the landlord, right? So they would actually be acting as an agent for the landlord, subject to the landlord's instructions in the mandate. The deposit is paid. Yes, it's held in an account that the estate agent has, sure. So they're physically in possession of it. But strictly speaking, the act speaks of the amount being released by the landlord, the land amount. Without specific or express instructions. Oh, sorry, my internet connection is quite bad.
Just a little.
Sorry, would an estate agent releasing it without specific instructions from the landlord be a contravention of the mandate?
Ultimately, I think you might be in a position where you are contravening the instructions of the landlord. Yeah, again, it's going to depend on the particular mandate. But yes, if you are acting on behalf of the landlord, you are going to have to follow the instructions ultimately. This is the difficulty with the question, I think, is if you're in a circumstance where you're not getting any instruction from the landlord whatsoever, how then do you react? Because you're not going to get the instruction from the landlord. Ultimately, I don't know what steps the question is about what steps exactly have been taken, but it's certainly a circumstance where, if you are an agent and you're acting on behalf of someone who is insisting on not communicating with you, you've got to bring the mandate to an end ultimately, I would think.
Sorry, I forgot to unmute myself there, guys. There's some serious drilling happening.
It's a new year, we're a little rusty, everyone.
We've got some serious drilling happening upstairs, so apologies in advance. So thank you very much, Nick and Bruno. So there you have it, Agent Chu. That is some of the guidelines that you can use just to attend to this specific scenario.